All right, good morning, everyone. Thank you for your patience. We're going to go ahead and get started. This is the state all-purpose calendar in the state court of Fulton County, Georgia. I'm Judge Melanie Williams, and at this calendar, we will address a variety of matters, including taking pleas, setting bonds as necessary. All defendants, I want to apprise you of your rights. You have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to counsel at this hearing today. As you can see, I'm conducting this hearing by video. I'm not in person there with you. That this proceeding is also being recorded. That means any member of the public can log on and watch. When I ask if you understand your rights, this announcement is what I am referring to. All right, who do we have first?
Judge, you got position 29.
Okay.
I have to need to speak because I was not able to.
Oh, I see. Need to speak. All right, so you need to interview your client, Miss Kim. All
Yeah.
right.
We can
All
go
right.
to 11 Gresham. Come on.
That is PD White.
Oh. Nice to meet you. Hey, my man.
PD White is. You can come in.
Mr. White, are you on the screen? And are you ready for 11?
I am.
All right, I have it. This is a negotiated plea.
That's correct, Judge.
Thank you. All right, good morning, Mr. White. I'm sorry, I apologize. Your name is Mr. Gresham, correct? All right, Mr. Gresham, good morning. Your case is 24 CR 0000733J. In this case, you are charged with battery family violence. You understand your rights today? All right. Ms. Falk?
Yes, Your Honor. Would Your Honor like me to put the facts briefly on the record?
Yes, please.
Okay. So for the offense of family violence battery, the state's recommendation is going to be 12 months served 90 days, credit for time served 32 days from February 12th to February 17th of 2024 and March 30th, 2025 to today. That would also include, let's see, my apologies, I lost my place briefly. FVIP, MHET, no further violent contact with Rhonda Gresham, and stay away from 1842 Marcone Street, Northwest in Atlanta. The state did reach out to Miss Gresham. We did speak to her, and she said she wanted the defendant to get help with his MH. She does believe that jail time will make this situation worse. The defendant currently will not be released. He will be concluded with our case. However, he would still have outstanding warrants for a 25 PI case that he would have to serve time on. And so that would not release him from the jail. As far as the facts of this case, just give me a moment.
Ms. Falk,
This occurred on January.
Ms. Falk, really quick, you said it was 90 days credit for 32 days. Was that so that he would still technically have time if that was the offer? Correct?
My apologies. Let me just double check. Yes, it is 90 days credit for time served 32 days. So yes, he would still have time. However, it would not, because he's on felony charges on a no bond, that would not essentially change his status.
Okay, understood. All right, please proceed.
Thank you, Your Honor. So this incident happened on January of 2024, and the defendant struck Miss Gresham, leaving visible marks on her, which led the police to make an arrest literally about a month later is when they arrested him on these charges. This occurred in their family home, and we do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. We do ask for you to sound for Miss Gresham at this time.
All right.
Full name is Rhonda Gresham.
Is Ms. Gresham present and wishes to make a statement?
Yes, I'm here.
All right, please raise your right hand. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge and is given under the penalty of, is she still there? There you are. And is given under the penalty of perjury.
Yes, ma'am.
All right. What would you like to tell me?
Well, I necessarily, I just wanted to make sure everything that I said, was spoken because she was talking, fast. I just wanted to make it very clear that, charges, I never wanted to press charges against my brother. My only thing I wanted to do, the police was only called just for his mental health sake. That's all. So, jail time or anything of him going to jail is not what I feel like that's best for him or what I want for him. All I want him to do is to get him some professional help as far as his mental health.
All right. I appreciate you coming to court and making that statement. Thank you, Ms. Gresham. Mr. White, do you still stipulate to those three elements?
We stipulate, Judge.
And your client wishes to go forward with the plea at this time?
He does, Your Honor.
All right, Mr. Gresham, please raise your right hand. Do you, excuse me, do you swear or affirm that the testimony you give today will be the truth to the best of your knowledge and is given under the penalty of perjury? All right, I'm gonna need you to speak very loudly for me so that I can hear your answers, okay?
I don't
You
want
do-
to.
You don't want to what?
I want to talk.
Okay, do you want to take a plea today?
Yeah.
Okay, sounds like we're not taking a plea, Mr. White. Sounds like we're waiving arraignment and going to trial.
Said I want to take my plea.
Okay, I'm telling you, you're gonna have to answer questions to take a plea, though. Okay, so do you want to do that?
Yeah.
All right. Are you under the influence of any drugs or alcohol at this time?
Bro.
Was that a yes or a no?
No.
All right. Did anyone promise you anything in exchange for taking a plea?
No.
Did anyone force you to take a plea today?
No.
Are you satisfied with Mr. White's representation?
Yeah.
Was that a no?
Satisfied with it.
All right, thank you. You understand you're giving up your right to trial by judge or jury?
Yes.
And you understand you're giving up your right to have the state prove this charge against you beyond a reasonable doubt?
Yes.
And you understand that taking a guilty plea can affect other aspects of your life, such as probation, immigration, employment, or things I may not be able to anticipate?
Yes.
And you fully understand the requirements of the sentence as
No.
explained to you by your
No.
attorney? You don't
No.
understand?
No.
You don't, would you like to speak to your attorney to understand the requirements that you have to undergo in a
12 months to serve 90 days, right?
Yes, but there are additional requirements, including an evaluation, no further violent contact with your sister, and you need to stay away from that address. Do you understand all of that? The address on Marcone Street.
Yes.
And you do understand that?
Yes, I do.
All right. As to the charge of battery, family violence, Mr. Gresham, how do you plead?
Guilty.
I accept your guilty plea at this time. Is there anything additional, Ms. Falk or Mr. White?
No, Your Honor.
No, Your Honor.
All right. Best of luck to you, Mr. Gresham. That concludes your case at this time.
We got this position people. Number 10, Mr. Fletcher.
All right. I have this as a negotiated plea as well.
That's correct, Judge.
Thank you. Good morning, Mr. Fletcher. Your case is 25 CR 001918J. In this case, you're charged with simple battery against a person who was either pregnant or 65 years old at the time of the offense, with the offense date of December the 11th of 2024. Do you understand your rights today?
Yes, ma'am.
All right. Thank you for speaking loudly. I appreciate that so much.
Yes, ma'am.
Ms. Falk, please proceed.
Yes, Your Honor. For the offense, the state's recommendation is as follows: 12 months served 60 days, credit for time served 14 days. That is from April 11th, 2025 until today. Balance probated, no further violent contact with Eloise Gleaton. BHET, 40 hours of community service, and that should say no firearms. This incident happened December 11th, 2024 at 534 Ontario Avenue. They spoke to Miss Eloise Gleaton, who stated her son, the defendant, had assaulted her earlier, had left the location. She stated he started asking her to run errands for him and asking for money, and then attacked her by placing his hands around her neck and pushing her to the ground. As she started to call 911, he grabbed her phone and threw it, hindering her from calling 911. The state would ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea, and we would like to sound from Miss Eloise Gleaton at this time. That's all for the state.
All right, and how many additional days is that? I'm doing the math myself.
16.
16.
Okay, 16 additional days. Is Ms. Gleaton present and wishes to make a statement? Okay, seeing none. Mr. White, do you so stipulate?
We do, Judge.
Thank you. Mr. Fletcher, please raise your right hand. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge and is given under the penalty of perjury?
Yes, ma'am.
All right. Thank you. You can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Did anyone force you to take a plea today?
No, ma'am.
Did anyone promise you anything in exchange?
No, ma'am.
And you understand by taking a plea, you're giving up your right to trial by judge or by jury?
Yes, ma'am.
And you're giving up your right to have the state prove this charges against you beyond a reasonable doubt?
Yes, ma'am.
And you're satisfied with Mr. White's representation?
Yes, ma'am.
And you fully understand the requirements, including the evaluation, the community service, and the no further violent contact additionally with Ms. Gleaton. And you also will have 16 additional days to serve in the Fulton County Jail. You understand that, Mr. Fletcher?
Also, rather than having 14 days, I had 16 days.
That's what I believe. Yes, 16 days.
Okay.
All right. Do you understand that and wish to go forward with the plea?
Yes, ma'am.
All right. As to the charge I previously read, Mr. Fletcher, how do you plead?
Yep.
I accept your guilty plea at this time. Is there anything additional, Ms. Falk or Mr. White?
Your Honor, we would just ask the probation go non-reporting once he completes his requirements.
Okay. I don't have, yeah, he can go non-reporting once he's completed it.
Thank you, Judge.
All right. I'm sorry. What Ms. Falk, would you like to put any objection to that onto the record?
No objection to non-reporting.
All right. You have a question, Mr. Fletcher?
So I'll be out in 16 days.
If you don't have other holds, yes.
All right, thank you.
All right. Take care. Have a good afternoon.
Position 14 and 15, Mr. Hancock.
All right. And the announcement I have for this is a plea as well.
That's correct, Judge.
All right. Thank you. Okay. It's not two FTAs. All right. Good morning, Mr. Hancock. You have two cases. Give me time to read those. Your first case is 23 CR 003200J. You're charged with theft of service and obstruction with the offense date of May the 19th of 2023. You also have 25 CR 001510J. You're charged with simple battery in that case with the offense date of March 23 of 2025. Do you understand your rights today?
Yes.
Is that a yes?
Yeah.
Okay. Ms. Falk?
Yes, Your Honor. For the defendant's first case on the charge of, position 14 on the charge of theft of service, the state's recommendation is 12 months to serve 10 days, credit for time served 5 days. That will be from May 20th to May 21st of 2023, November 3rd to November 5th of 2024. Balance probated. Stay away from Dakota Blue, located at 454 Cherokee Avenue in Atlanta, and an anti-theft course. On count 2, 12 months concurrent with count 1 and a $300 fine. As for position 15, the simple battery, state's recommendation is 12 months served, 60 days, credit for time served 31 days from March 23rd, 2025 until today. Balance probated, no further contact with Deandra Williams, and stay away from Marta until April 23rd of 2026, BHET. The state's recommendation is based on the fact that on May 19th of 2023, the defendant entered the Dakota Blue, obtained food and drink and then left without paying his bill of $15.25. When police attempted to arrest him, he didn't comply with the lawful commands of the police officer and he fled on foot. On the second case, the simple battery, that incident happened at 5 Points MARTA station. Miss Williams stated she was checking her bag, felt an unknown male behind her who grabbed her and gave her an unsolicited hug. The incident occurred in the area of the women's facilities. She was not harmed, but she also stated she did not know Mr. Hancock and did not want the hug. The states would ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. We did have an opportunity to speak with Ms. Deandra Williams. She does agree with the plea and stated she did not wish to attend the Zoom, but we will sound for her out of an abundance of caution for Marcy's Law purposes. That's all for the state.
Dakota Blue is a restaurant, I'm assuming?
Yes, Your Honor, it is.
Okay. All right, is Ms. Williams present and wishes to make a statement? Hearing none. Mr. White, do you so stipulate?
We do stipulate, Judge. Briefly, though, Mr. Hancock would like to enter a NOLO plea to the charges. Also, we'd ask that the probation terminate or go non-reporting once he completes all of his requirements.
Does the state have a position regarding the NOLO?
On which case, the simple battery or the theft of service?
Both cases.
I would agree with it for the theft of service, disagree with it for the simple battery. And I don't have a problem with non-reporting.
Okay. Ms. Hardy,
Yes, Your Honor.
can I have this defendant's history, please?
Okay, which position?
Position 14 and 15.
Okay, one moment.
And actually, Your Honor, I would like to modify that. He entered a NOLO contendere plea in 2024. He would not be eligible.
Eligible. Okay, that was what I was checking. Okay, so Mr. White, he can't take a NOLO.
I'm sorry, Judge, that depends on what the NOLO is on.
Well, let's see.
The
What
NOLO
was
was
it?
for theft by shoplifting.
Okay, then the simple battery, then obviously on the theft, he wouldn't be eligible for NOLO, but on the simple battery, he still would be. Those.
Okay, let me hear his history then, Ms. Hardy.
Okay, Your Honor, he has a total. One moment. Okay, he has a total of 6 arrest cycles. One failure to appear, 2024. There's a theft by shoplifting where he took the NOLO plea in 2024. And nothing further to report.
Okay. All right, I'll let him plead NOLO to the simple battery if he wishes to move forward, but he will have to plead guilty to the theft of service. Does he wish to do that, Mr. White?
Yes, fair enough, Judge.
Okay. All right, Mr. Hancock, please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge and is given under the penalty of perjury?
Yes.
All right, thank you. You can put your hand down. Are you under the influence of any drugs or alcohol at this time that would affect your ability to understand this proceeding today?
No.
Did anyone promise you anything in exchange for taking the plea?
No.
Did anyone force you to take a plea today?
No.
And you understand by taking the plea, you're giving up your right to have a trial by judge or by jury?
Yeah.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yeah.
And you fully understand the requirements, including staying away from Dakota Blue, taking an anti-theft course, and paying a $300 fine as it pertains to your first case. And in the second case, you are to stay away from MARTA until April of 2026 and undergo some evaluations, and additionally have no contact with the victim in that case. Do you understand all of that, Mr. Hancock?
Yeah.
All right. And you further understand that taking a guilty plea may affect aspects of your life that I can't anticipate, such as employment, immigration, probation, things of that nature?
Mhm. Yeah.
Okay, and you're satisfied with Mr. White's representation?
Yes.
All right, in case ending 3200J, theft of service and obstruction in which you were charged, how do you plead, Mr. Hancock?
Obstruction.
I'm sorry, say that louder.
Oh, which one was that?
This is the theft of service. You're not eligible for a NOLO plea here. How do you plead to that case?
Oh, guilty.
All right, I accept your guilty plea in that case. All right, in the case ending in 1510J, in which you're charged with simple battery, how do you plead, Mr. Hancock?
Nolo.
I accept your no plea at this time. Is there anything additional from State of Defense?
Your Honor, we'd just like to register our objection to the use of the Nolo plea on the simple battery case.
Understood. Anything additional?
No, Your Honor.
All right, best of luck to you, sir. That concludes your case.
All right.
Number 6, Collins.
This one is a plea as well.
That's correct, Judge.
All right, Mr. Collins, your case is 25 CR 001925A. You're charged with 2 counts of battery family violence, 1 count of simple battery family violence, and 1 count of obstructing someone attempting to make an emergency call. Do you understand your rights today?
Yes.
All right. Ms. Falk, please proceed.
Yes, Your Honor. In this case, on count 1, this battery family violence, 12 months served, 120 days, credit for time served, 14 days from April 11th, 2025 until today. Balance probated, no further contact with Brittany Norman, 40 hours of community service, FVIP, and no firearms. Count 2 and 3 will merge with count 1. They were charged in the alternative. Count 4, the obstructing and hindering of a 911 call, it will be 12 months served, 120 days. Credit for time served, 14 days, balance probated, concurrent with count 1. We did have an opportunity to speak with the victim, Miss Brittany Norman. She stated she agrees with the plea, but would like no further violent contact. However, given the circumstances of the case, we would like, Your Honor, to consider no contact at all. The incident happened March 12th, 2025. At 2900 Far Court South Northwest. The officer spoke with Miss Brittany Norman, who stated she was physically assaulted by the defendant. They did previously live together. She stated that she told him he had to sleep on the floor. He became upset, bit her right forearm, scratched her, and took her cell phone to prevent her from calling the police. Miss Norman's mother, Miss Sylvia Norman, did witness the incident, called the police, and she stated she saw the defendant throw her daughter on the bed, get on top of her, and try to break her wrist in order to take the phone away from her. We do ask the defense to stipulate to venue, factual basis, and identification for the plea, and that's all for the state.
All right, is Ms. Norman present and wishes to make a statement? Okay. Mr. White, do you so stipulate?
We stipulate for the purposes of the plea, Judge.
Okay. All right, Mr. Collins, please raise your right hand. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge and is given under the penalty of perjury?
Yes.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No.
Did anyone force you to take a plea today?
No.
Did anyone promise you anything in exchange for taking a plea?
No.
And you understand you're giving up your right to trial by judge or by jury?
Yes.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes.
And you further understand the requirements that you are to have no contact with Ms. Norman, complete 40 hours of community service, a family violence intervention course. And how much additional time does he have to serve, Ms. Falk or Mr. White?
46 days, Judge.
And you'll have an additional 46 days in the Fulton County Jail. Do you understand all of that, Mr. Collins? All right, as to the charges I previously listed, how do you plead?
Guilty.
I accept your guilty plea at this time. Is there anything additional from state or defense?
Nothing, Your Honor.
No, Your Honor.
All right, best of luck to you, Mr. Collins. That will conclude your case.
Number 43, Watts, I'm sorry, 43 Watts. Your Honor, actually, I received an email from Failed Project that his bond was paid. So I think it's supposed to be processed.
Oh, so Mr. Watts is not taking a plea today? He's gonna just bond out?
I believe so.
I mean,
Mrs. Jordan, do you see his bond is on there before we move on?
I haven't seen one. Did you speak?
I gotta admit. May I please have 1 minute to discuss?
Yes, let's can someone help me verify, please?
Can Mr. White call courtroom two, please? There's two clients that need to be, interviewed.
Got it.
So the bond hasn't been posted on the jail screen yet, Your Honor.
Okay, Miss Kim, are you sure? Because we're not seeing it, and I don't want
Oh, maybe they need the pages. That's what we want to take a plea.
No, I don't do it. Yes, sir. To be honest with you,
let's mute courtroom two.
because it was a misunderstanding.
Your Honor, who was the defendant who's going to bond out?
It was 43 that Miss Kim thought he had a bond, but Mr. Jordan is not seeing it. So
Oh,
we're
okay.
trying to figure out what we're doing.
Understood.
Yes, Your Honor, I confirmed again with a bail project. It should be processed, so he would like to waive his arraignment, and then we will wait for the bond to be posted.
Okay, so we'll rate. You're going to enter the waiver,
Yes.
and we will reset for the notice. All right, Mr. Watts, your attorney is entering waiver of arraignment, and you're entering a not guilty plea. Your case will be reset for another day.
Your Honor, may I make a request on this one?
Sure. Uh-huh.
Because we sometimes have problems when it hasn't occurred yet, and it's
Want to
reset for
reset
the
to
notice.
next week?
Yes, please. And we don't have to
Okay.
put it on the calendar if he bonds out.
Okay, so we're gonna reset this case to next week's SAP just to make sure the bond goes through.
Sure, thank you.
I was employed before I got arrested.
Okay, all right, who do we have next?
Number 29. Yes.
29.
Yes, Your Honor. This will be a negotiated plea, Your Honor.
Okay, thank you.
Yes. Yes.
Okay, pronounce your last name for me, sir.
Onoha.
Mr. Anoha, your case is 25 CR 001930Y. In this case, you're charged with criminal trespass. You understand your rights today?
Yes.
All right, thank you. Mr. Sirocco, please proceed.
Thank you, Judge. Good morning.
Morning.
The state's recommendation for the criminal trespass is 12 months to serve 26 days, credit for time served 13 days. That is from April 12th, 2025 to present. Balance suspended. Stay away from the Quick Trip at 4975 Windward Parkway in Alpharetta. Just briefly, this took place on April 11th, 2025. At that location, law enforcement responded to a trespass call and was made aware that the defendant had been previously given a criminal trespass notice from the same Quick Trip earlier that evening, less than an hour beforehand. We asked the defense to stipulate to factual basis, venue, and identification for purposes of the plea.
Yes, we do.
All right, Mr. Anoha, please raise your right hand. Do you swear? Oh, please raise it for me. Thank you. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge and is given under the penalty of perjury?
Yes.
All right, you can put your hand down. I'm going to ask you some questions to make sure you're taking a plea voluntarily this morning, okay? Are you under the influence of any drugs or alcohol at this time?
No.
Did anyone promise you anything in exchange for taking a plea today?
No.
Did anyone force you to take a plea?
I don't understand. No.
Okay. Did any and you understand you're giving up your right to trial by judge or by jury?
Oh, yes.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt.
Yes.
And you understand the requirements that you cannot go back to that Quick Trip, but otherwise the time you served in Fulton County Jail should close your case?
Yes.
And you're satisfied with your attorney's representation?
Yes.
All right, as to the charge of criminal trespass, how do you plead?
Guilty.
Was that a guilty?
Yes.
All right, I accept your guilty plea. Is there anything additional from the state or the defense?
Nothing from
No,
Your
Nothing
Honor.
from the state, Judge.
All right. Best of luck to you, sir. That concludes your case. Don't go back to that quick trip, okay? Bye-bye.
Good morning, Judge.
Good
I do have a
morning.
quick announcement. Good morning. I have a quick announcement for position number 44. It's going to be Ashley White. It says on the announcement that she is released, but she's actually here with me now. So I'm wondering who would be the attorney that she needs to be interviewed.
Okay, so Miss White didn't make bond. Can someone speak with her?
Can she call courtroom 2? Either Paul is gonna be answering the phone, PD Patel's.
Okay, if Martell is available, I can call now.
Yes, he's right here at courtroom 2.
Okay, I'll give a call.
So is that for Ashley White?
Yes.
That is correct. Ashley White is position number 44.
Did
She's
she
not
make
released. She's
bond?
currently here. No,
Is there a bond?
she's right.
But is there a bond posted on the screen?
What's her date of birth? I think it's a different Ashley White.
Do we know her date of birth?
August 27, 1986. August 27, 1986.
Oh yeah, that's not who's on the calendar.
That's not the one that's on the calendar.
So I think we have the wrong person. I think that Ashley White, who was on the calendar today, did bond out.
Judge, I have the Ashley White that we have on the calendar today bonded out on April 19th.
Yeah, so I think this is a different Ashley White who has a different case that's not on this calendar today. Is that correct? I think that's what's happened there. So Miss White's case, the Miss White that's with you will not be addressed today. A different Ashley White has made bond and is on this calendar today.
Okay. Okay, thank you.
Okay, thank you. All right, are we ready for our next position?
Position number 3, Mr. Artis.
All right, Mr. Artist, your case is 25 CR 001924B. You're charged with criminal trespass and damage to property. You understand your rights today?
Yes.
Okay, I don't have an announcement for this one. Do we, what is the announcement?
My
Judge,
apologies. Your Honor. Which position is this? Is this 25?
Number
Number 3.
3, I'm
Ah.
sorry, 3.
Thank you. My apologies.
Yes, Judge, he wasn't feeling well yesterday and didn't come out to be interviewed, so I just spoke with him and he is going to be a negotiated plea.
Okay, thank you. Please proceed, Ms. Falk, if you're ready.
Yes, Your Honor. This case for the criminal trespass and damage to property, the state's recommendation on this is 12 months served 28 days. That would be credit for time served for 14 days. That's going to be from April 11th, 2025 until today. Balance suspended. Stay away from the height of Lenox, located at 3200 Lenox Road Northeast in Atlanta, Georgia. In this case, Your Honor, on April 11th, 2025, the defendant entered that location and was observed forcibly entering a vacant unit, damaging the door in the process, and was still occupying the space. The officers went inside and identified the defendant, who was hiding in a closet, and was arrested. The state would ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. That's all for the state.
So stipulated, Your Honor.
All right. Mr. Artist, please raise your right hand. Do you swear or affirm that, Mr. Artist, do you want to move forward and take a plea today?
Yeah.
All right. May I place you under oath? I'll need you to raise your right hand.
Yes.
All right. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge and is given under the penalty of perjury?
Yes.
All right. You can put your hand down. Thank you so much. Are you under the influence of any drugs or alcohol at this time? I'm sorry, I can't hear you. I need you to speak up. Are you under the influence of any drugs or alcohol at this time?
No.
Did anyone force you to take a plea today?
No.
Okay. Did anyone promise you anything in exchange for taking a plea?
No.
And you understand you're giving up your right to trial by judge or by jury?
Yeah.
Is that a yes?
Yeah.
And you fully understand the requirements that you cannot go back to that location on Lennox Road?
I understand that.
All right, you do understand. Are
Yeah.
you satisfied with your attorney's representation?
Yeah, I guess.
Is that it has to either be a yes or a no?
Yes.
All right. As to the charge of criminal trespass and damage to property, how do you plead?
I plead guilty to the criminal trespass.
Oh, the charge is criminal trespass and damage. How do you plead, Mr. Artis?
It's one charge.
It's one charge.
I plead guilty.
I'm sorry, say that again.
I plead guilty.
All right. I accept your guilty plea at this time. Is there anything additional, Ms. Falk? Mr. White?
Nothing.
No,
From the
Your Honor.
state.
All right. Best of luck to you, Mr. Artis. That concludes your case.
Petition number 2, Arnold.
Okay, and the announcement, Mr. White?
Your Honor, Mr. Arnold's going to be a bond hearing.
Okay. Thank you. Hold 1 second. All right, Mr. Arnold, your case is 25 CR 001986A. In this case, you're charged for battery, family violence, simple battery, and another count of battery, family violence with the offense date of March the 30th of 2025. Do you understand your rights?
Yes.
All right, Miss Hardy, can I please have this defendant's history? This is position 2.
Yes, Your Honor. One moment. Your Honor, can we come back to me? It's still downloading.
Do you have it, Ms. Falk?
I do, Your Honor.
All right, please proceed.
This defendant has, let's see, he has 6 previous cycles. There is this cycle. There was an aggravated assault and cruelty to children that was dead docketed, but he, let's see, and there was a 2018 probation violation out of Clayton County State Court where he received 45 days confinement, a 2018 second probation violation where he was continued on original probation, marijuana less than an ounce conviction in 2020 out of Clayton County State Court, and a case of giving false name, marijuana less than an ounce, and giving false name where his case was dismissed after completion of pretrial diversion. The case that was dead docketed is currently under 23 SC 188309. It was against the same victim, and it was an aggravated assault case, I believe, that was dead docketed. And this case involved the defendant. The officer was conducting patrol in East Point, observed Chloe Armstrong, who's the victim, sitting at the corner of the intersection with a bloodied face. The officer also observed the defendant approaching her from further down the road. The officer turned his patrol vehicle around to make contact. He then observed Mr. Arnold grab Miss Armstrong by her clothing while Miss Armstrong was attempting to pull away. The officer then talked to Miss Armstrong. Miss Armstrong disclosed that they had been coming back from a location, and that they were coming back from her grandmother's location. They began verbally arguing, and the defendant then punched her in the face with a closed fist. The officer did observe bloody injury to the face, nose, and mouth, and Ms. Armstrong also stated the defendant grabbed her by her face, causing her nose to bleed. I would just like to note that the victim in this case is the stepdaughter of the defendant. We do ask that there is no bond set on this because it was originally charged as a cruelty to children. The cruelty to children was then downgraded because there was no evidence of a broken nose. And it does state the defendant had a prior domestic violence case against the mother from 2 years ago that was dead docketed. The daughter in this case, the stepdaughter, was also included in that bond condition to have no further violent contact. For that reason, the state is going to ask for a $10,000 surety bond. We do believe that this is a situation that is continuing to escalate. He had a previous case that was placed on the dead docket in 2023. Now it's 2025, and we have an officer actually observing the defendant grabbing the victim as she's struggling to get away from him, her face bloodied, and her stating that he punched her in the face, which would be, I believe, corroborated by the activities of the defendant that were witnessed by the officer. And for that reason, we are asking for a $10,000 surety bond, that the defendant stay away from Miss Armstrong, the victim, and that the defendant have no contact with her, have no firearms. And we are asking for FVIP. I know that is not usual in cases where it's a bond condition, but we are asking for FVIP. The victim in this case is 14 years old.
Okay. It's either Miss Armstrong or Miss Armstrong's mother on the line. What she
Yes.
said. Okay, please turn on your camera.
Give me.
Lexi Poo.
Okay. How
Please
you
raise
doing?
your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge and is given under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand down. Please state your full name for me.
Alexis Armstrongville.
Okay, what would you like to tell me?
We were coming from my daughter's grandma. She called me because my daughter was not doing right. I went to go pick up my daughter. It was Sunday, so I went to go round up all my children. Chloe had attitude because Chloe doesn't go to regular school. She's virtual. So she wanted to stay a couple more days with her grandma. And I told her no. So she had an attitude the whole time. Her dad asked her, well, Mr. Arnold asked her to hand her a baby bag, and she refused. And she tried to get out the car, and he restrained her. And she even told the lady that called yesterday that he did not punch her. She hit her nose when he was restraining her. She fled out the car. I had my infant child with me, so I could not go after her. So he chose to go after her and grab her. I have history of Chloe having. I had to call the cops on Chloe because she put her hands on me. I have also paperwork on Chloe's behavior, being defects cases. I have plenty of paperwork on Chloe being a bad teen. So, we've been having problems with her for a while, ma'am. She is at that age where she wants to do what she wants, and we're not having it.
Okay. All right, I
Your
appreciate
Honor,
you.
if I may ask the witness just one question.
Very briefly. Go ahead, Ms. Falk.
And ma'am, the defendant had a case against you in 2023, isn't that correct? As well as your daughter.
This case,
It's a
Judge.
valid question, Your Honor.
Right.
It's related to the conditions of
I-
bond.
So, ma'am, so the case between me and him, it was an incident.
We don't have
yes,
to get
but
into
the
that.
reason-
It's okay. Let's
You
leave that
sure?
where it
Because
is.
the reason why it was a case with my daughter is because she was in the household when me and him was having the argument. That's why that's why she was involved in that case, ma'am. Because she was in her room when me and him was having the
Your Honor,
argument.
irrelevant to this case.
It is relevant
Okay.
to the conditions of
All
bond
right.
and the analysis factors, Your Honor.
All right. Thank you for making that statement, Ms. Armstrong. I appreciate it. All right, Mr. White, please proceed.
Your Honor, so we have a completely different narrative from an actual witness to the case as to what actually happened, and then stating that Mr. Arnold did not strike the alleged victim. He's employed here. He's been working for Special Services Logistics for some time now before this arrest. I'm not sure if he's going to be able to get that job back or not. Additionally, he's been held in jail at this point 20 days on a no bond, which it appears that he was completely wrongly accused to begin with, and then absolutely incorrectly accused. As far we're asking that he be allowed to sign his own bond at this time. Other than the one dead docketed case that has been beaten into the ground, he has a very light history, and we're just asking that he be allowed to sign his own bond and get back to work.
All right. I will not be giving him a signature bond at this point. All right, defendant has no bond currently, is that correct?
That
That's
is correct, Your Honor.
Okay,
I mean,
hold on.
technically, Judge, we could argue that this is a violation of Riverside, in fact, that he
It
hasn't
is
been.
not a violation of Riverside. Riverside
Okay.
requires you to
Okay,
have a
miss,
first
we
appearance.
don't have to, we don't
I'd
have
like
to.
to finish my argument.
You can, but it's not a Riverside, but go ahead if you want to hear it and I'll let Ms. Falk respond. Go ahead.
Well, I just would like Ms. Falk to let me finish before she.
Well,
step-
I'm letting you finish, Mr. White. Go ahead.
No, we'll let it go, Judge. It's fine.
I mean, if you want to. I have no objection to hearing it. Okay. All right. So defendant is going to receive a $6,000 surety bond. That'll be, let me see. Let me get it correct. Oh, that wasn't correct. Okay, we'll just stick with it. 2,500 on each battery family violence and 1,000 on the simple battery family violence to get us to that 6,000. He's to have no contact with Miss Armstrong, no alcohol, no drugs, no weapons as a condition. And I guess he gets reset for the notice.
That's correct, Judge. We'd be entering not guilty.
Yeah, that's correct. I was making sure that we couldn't reset him to SAP again. Okay. So that bond will stay as that, and then he gets reset for the notice. Is there anything additional, Mr. White, Ms. Falk? And I do understand your position, Mr. White, but I also don't agree that it's Riverside, okay? Oh,
Sure. Okay.
all right. Anything additional?
Nothing from the state.
All right.
No, Your
All right. Best of luck to all parties concerned. The case is now closed for this time. All right. Who do we have next?
Next, Judge, we have position number 7, Ms. Cranford.
Okay, this one, it says, we're doing a bond hearing for this one as well. Is that the announcement, Mr. Bart? It says Mr. Bartel's, not guilty waiver in a bond hearing.
Honor, Mr. Patel is on the phone with another
Oh,
client.
we can't do that one yet. Can we go somewhere else?
Yes, please. We can do number 21, Mr. Long.
I'm sorry, Ms. Watson, you were saying something?
Yeah, I'm just not sure. I was appointed last night for Tyree Moore. And I haven't had an opportunity to speak with him. I'm not sure if he's on this calendar.
He's here in the courtroom. You can call 404 612 2060. Go to the phone number.
All right, thank you.
And I'm sorry, we're doing position
Number
30,
21, Mr. Long.
21. I had 41. Okay.
Sorry.
All right. That's all right. I apologize for that. All right. And the announcement is this is a negotiated plea.
Yes, Your Honor.
Okay. Mr. Long, your case is 21 CR 005912E, and you're charged with reckless conduct. You understand your rights?
Yes, I do.
All right. Ms. Falk, please proceed.
Yes, Your Honor. This is one count of reckless conduct. State's recommendation is 12 months served 32 days, credit for time served 16 days from April 9th, 2025 until today. No further contact with Devin Casey and 12 weeks of anger management. This incident happened January 26, 2020. A vehicle was driving on 689 Cascade Road. The driver stated that her son, who's the defendant, grabbed her steering wheel while she was driving, causing her vehicle to veer into a second vehicle. The defendant also had a different case on the same day, which he was convicted on. And that is the reason for the state's recommendation in this case. It was kind of just hanging out there as part and parcel. Again, totally different act, same day, separately. And so the state's recommendation is reflective of that. We would like to sound for Devin Casey, and who is the victim in the other vehicle. And we do ask the defense to stipulate to venue factual basis and identification for the purposes of this plea.
Okay, is Devin Casey on this Zoom conference and wishes to make a statement? Hearing and seeing none, do you so stipulate, Ms. Kim?
Yes, Your Honor, we would like to request that probation to be terminated, Your Honor. This case was from 2020, 5 years ago, and either terminated or non-reporting, Your Honor.
Okay, it can terminate once he completes all the requirements.
Thank you, Your Honor.
All right, Mr. Long, please raise your right hand. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge and is given under the penalty of perjury?
Yes.
All right, you can put your hand down. All right, are you under the influence of any drugs or alcohol at this time that would affect your ability to understand the proceeding today?
No.
Did anyone force you to take a plea today?
No.
Did anyone promise you anything in exchange for taking a plea?
No.
And by taking a guilty plea, you understand you're giving up your right to trial by judge or by jury?
Yes.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes.
And you understand that taking a guilty plea can affect other aspects of your life, such as probation, employment, immigration, other things I may not be able to anticipate?
Yes.
And you understand that you cannot have any contact with Devin Casey, but otherwise the time you served in the Fulton County Jail will close your case, but you also have to take 12 weeks of anger management. Are you fully familiar with the requirements and do you understand them?
So if I come in contact with the victim, I have to take 12.
You can have no contact with the victim. You're going to take 12 weeks of anger management, but you should not have additional time to serve in the Fulton County Jail. Do you understand that?
Yes.
All right. As to the charge of reckless conduct, Mr. Long, how do you plead?
Yeah, guilty.
I accept your guilty plea at this time. Is there anything additional from state or defense?
Just briefly, Your Honor, I wanted to put on the record that the other related case was 20 SC 175165.
Okay. 20
Thank you.
SC
175165.
Thank you, Ms. Falk. All right. Anything additional, Ms. Kim? Sounds like no, maybe, perhaps.
Sorry, I'm sorry to
Anything additional, Ms. Kim?
Nothing further from defense, Your Honor.
All right. Best of luck to you, Mr. Long. That concludes your case at this time.
All right, thanks.
Have a good day. Who do we have next?
Judge Williams, I'm trying to see if Mr. Bartel is going to be available because his cases are over here at ACDC.
Is Mr. Bartels free or is he still on the phone?
Yes, Your Honor, I'm here.
Next.
You're back, Mr. Bartels. He's back.
Yes, good morning, Judge.
Good morning. Good to see you.
Good to see you, Your Honor.
All right. ACDC hasn't heard their rights, have they? So I'm going to go through those again. Good morning, all defendants at ACDC. I am Judge Melanie Williams. Today is April the 24th of 2025. I want to explain your rights to you. You have an absolute right to remain silent. Anything you say can and will be used against you. You also have a right to attorney at this proceeding. As you can see, I am conducting this hearing this morning by video. I'm not in person with you. That means any member of the public can log on and watch this particular proceeding as it's being live streamed. It's also being recorded. When I ask if you understand your rights, that is what I am referring to. And who do we have at ACDC now?
This is position number 7, Ms. Cranford.
Okay. And I don't have an announcement. What's the announcement, Mr. Bartels? Is a bond hearing?
Yes, Your Honor. On the case itself, we are going to be entering a not guilty plea. I've talked with Ms. Cranford and advised her of her options. So we'll enter a not guilty plea and file a waiver of arraignment. Regarding the bond hearing, we would just ask to be heard on a possible signature bond or a bond reduction.
Okay. All right. So, Ms. Cranford, let me read your case. Your case is 25 CR 001906Y. You're charged with theft by shoplifting, giving false name, 2 counts of that, with the offense date of April the 10th of 2025. Do you understand your rights today?
Yes, Your Honor.
All right. Let me go back. You say you do understand your rights?
Yeah, Ms. Cranford, you have to speak up.
Okay, thank you. Ms. Hardy, do you have the history or should I ask Ms. Falk?
I have it.
Okay, please
This
proceed.
defendant has 10 arrest cycles in Georgia. There was a misdemeanor conviction in 2016 for driving while license suspended or revoked. 2 FTAs from 2023. And there appears to be a hold out of Marietta for an FTA, and the date of that warrant is January 6, 2025. Nothing further to report.
Okay. And
I'm
what's the
seeing
current bond?
$2,000 surety, Your Honor. It broke down. Judge Law entered a bond, $1,000 good, $500 good on the 2 remaining counts. Stay away from all Sephora and Lenox Mall at 3393 Peachtree Road in Atlanta. No drugs, alcohol, weapons, or firearms. I believe that was based on not only the FTAs, which were fairly recent. The last one was June of 2023, but also on the fact that she has 2 other pending shopliftings, one in Roswell Municipal Court that was transferred over to state court on July 17th of 2024, and then one from Cobb County, which was June 19th of 2023. Actually, she has 3 pending shopliftings. There's another theft by shoplifting from Cobb County where she was arrested May 30th of 2023. So this is her 4th theft by shoplifting pending. She also has a theft by taking that it looks like there was a time expired restriction November 16th of 2021, and a null prost theft by receiving in 2023 out of Cobb. And so I believe that it was based on not only her FTAs, but her repeat cycles of theft that led to a $2,000 surety bond. This incident did happen at the Sephora. The defendant entered the store and was flagged because she was running from the location. She was seen removing items as she was walking through the store and throwing them in a bag. When they brought her back, she was observed removing items and tossing them onto the shelves. The value of those items were $80.58, and she had been observed concealing the items and then exiting the store, which is what led to them grabbing her and bringing her back to the store. She did give a false address and a false name and date of birth when she was arrested. And that may be because she also has a pending hold out of, Cobb County. I believe that would be for one of the shopliftings.
Well, Your Honor, I again have spoken with Ms. Cranford about this case and about her situation. She does deny the allegations. In this report, she indicates to me that she did pay for these items. So that's why we're entering a not guilty plea, and she does enjoy the presumption of innocence. Regarding the failures to appear, she indicates to me she didn't get notice of those court dates. That does happen often. With regard to the case in Cobb County, Ms. Falk, is that from Cobb County, the hold, or Marietta? Because the only case I found in Cobb County on their website, and I looked in state and superior court, was null pros 2 years ago.
It's showing out of Cobb County SO. So it doesn't give me any specific detail, just showing it's a case out of Cobb County SO.
Yeah, like I said, Your Honor, the only case I'm aware in Cobb County that I found on their website for all courts was null pros. So that warrant very well could be an error. Regarding the bond, she's wanting to ask the court to either consider a signature bond. If she doesn't qualify for that, her mother, spoken with her mother on the phone, she indicated that she may be able to make a lower bond. So we would also ask the court to consider reducing it to a $500 good bond on the shoplifting charge and $250 on each of the other charges for $1,000 total. And that's all for defense right now. Well, I would note she's been in jail for 15 days so far.
Okay. Yeah, she can't get a signature bond because of the other theft by shoplifting or theft by taking it, so bond restricted. Okay, so I will, how many days has she been in, Mr. Bartels?
15 days, Your Honor.
Okay, as to the 2 counts of giving false name or address, I'll make those $500 each signature bond through the jail. As to the theft by shoplifting, she's gonna get an $80 cash bond. Okay, so that's a little bit of a weird number. So it's gonna be 1,080 split bond.
Okay, I appreciate that, Judge. I'll give that order today. Is Mr. Jordan getting the orders?
He is.
Okay, all right, thank you.
And
Judge.
with all the same conditions as existed previously.
Very well. Thank you, Your Honor.
All right. Take care. Best of luck to you, Ms. Cranford.
Number 37, Mr. Stetson.
All right. Give me 1 second. We will be right back. All right. Thank you for your patience. My apologies. What position is this?
Number 37, Mr. Stetson.
Okay, Mr. Stinson, your case is 25 CR 001802J. You are charged with simple battery in this case. Do you understand your rights?
Yes, ma'am.
All right, I have that this is a negotiated plea.
Yes, Your Honor.
All right, thank you, Mrs. Sirocco. Please proceed.
Thank you, Judge. The state's recommendation for this case on the simple battery is 12 months probation to serve 60 days. Credit for time served 21 days. That is from April 4th of 2025 to present. Balance probated for there being a mental health evaluation and treatment. No further contact with the victim in this case, LaRoden Spencer. Just briefly, this was from March 17th of 2024 at 550 Peachtree Street, which is the Emory University Hospital. The defendant was being transported there, and while en route, he became belligerent towards EMS staff, including LaRoden Spencer, whom, when that victim opened the door, the back door of the ambulance, the defendant intentionally threw urine on her. We would ask that we want to sound for LaRoden Spencer and ask the defense to stipulate the factual basis, venue, and identification for purposes of the plea.
Do you so stipulate, Ms. Kim?
Your Honor, I would like to apologize, but this has to be a non-negotiated plea. My client wants to know if we can reduce the jail time, since he has been in jail for more than a year for other cases. And it's been very, very long time for him to be outside of the jail, so.
Judge, if this is not negotiated plea, I'd like to go into the history of it.
All right, hold 1 second. Okay, let's sound first for LaRoden Spencer. Okay, Mrs. Rocco, yeah, go ahead and give me the history, please.
Thank you, Judge. There are, with respect to the history here, there are several violent convictions. I see simple assault, 1999, assault on a female and injury to personal property in 2015. Those were both in North Carolina. with respect to Georgia, oh, actually, in Florida, there was a robbery, strong arm conviction, and a damage to property / criminal mischief conviction as recently as 2023. Additionally, in Georgia, I see battery conviction, possession of cocaine, 2011. And yes, that's what I have for this, given the history of violent offenses. The state's offered an original recommendation is appropriate for 60 days.
And how many additional days would that be? I'm doing the math.
So 9.
Yes, 9 more days.
Okay. Okay, Ms. Kim, please proceed.
Yes, Your Honor, he denies that it was not a robbery actually. And Your Honor, the cases are kind of remote. It's 2011 to 1999. And this case is also 1 year old. Your Honor, we would like to request for the jail time to be reduced.
You're asking for it to be a time served plea?
Yes, that would be the best.
Okay, let me look at one thing. And what was the most recent cycle again, Mr. Sirocco?
That was just the most recent conviction. It looks the most recent cycle would be what is presumably open a possession of Schedule II controlled substance and possession or use of drug-related objects, 2024 arrest, Douglasville. But the most recent conviction was that robbery strong arm. That's how they qualify it there, and damage to property and criminal mischief. That's 2023.
Okay. Ms. Hardy, do you see anything else? I just want to verify with pretrial.
No, Your Honor, nothing to add.
Okay. Okay, Ms. Kim, in light of this history and that recent cycle in 2024, if he takes the plea today, I am going to accept the state's recommendation. Does your client wish to go forward?
He would like to move forward, Your Honor.
He does want to take the plea. All right, Mr. Stinson, please raise your right hand. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge and is given under the penalty of perjury?
Yes, ma'am.
All right. Are you under the influence? You can put your hand down. Thank you. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
Did anyone force you to take a plea today?
No, ma'am.
And you understand by taking a guilty plea, you're giving up your right to trial by judge or by jury?
Yes, ma'am.
And you further understand you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes, ma'am.
And you understand that you're going to have 9 additional days to serve in the Fulton County Jail. You cannot have any contact with the victim in this case, and you're going to undergo an evaluation. Do you understand all of that, Mr. Stinson?
Yes, ma'am.
All right, as to the charge of simple battery, how do you plead? I'm sorry, I didn't hear you. How do you plead?
Guilty.
I accept your guilty plea at this time. Is there anything additional from state or defense?
Nothing from the state judge.
All right, best of luck to you, Mr. Stinson. That concludes your case.
Next, Judge, I have position number 20, Ms. Lee.
Yes, Your Honor. Ms. Lee, can you hear us?
I can hear you.
All right, the announcement I have is, bring and hold for announcement. So yes, Mr. Bartels, what's your announcement?
Yes, Your Honor. I spoke with Ms. Lee yesterday and advised her what her options are and what the state's plea offer was. And she indicated she just wanted a little more time to think about it. Ms. Lee, have you decided what you want to do?
No, I didn't want more time.
I'm sorry?
I didn't say I wanted more time to think about it. I said that I had a public defender at the time, and
Do you want to why don't you give her a call? Because I'm afraid of what we might hear.
Well, I think you might want to clarify, Ms. Lee. Do you want me to represent you today or not?
I don't know. He described the charge. You described the charges to me, and I don't know. I don't know.
So, let me first hold on. Miss Lee, let's make sure you understand. Your case is 25 CR 001914D. In this case, you are charged with theft by shoplifting, and Mr. Bartels is a public defender. Do you wish to have his assistance today?
I don't. Like I said to him, I don't mind. I just don't. I don't know why this is another.
Okay, I don't want you to say too much. Do you do wish to have his assistance, and he told you your options? Do you wish to move forward and take a plea today?
Well, I mean, he's already there, so I don't know. I don't.
Okay, Mr. Bartels, I'm sorry. Will you just give ACDC? Can you call courtroom 2 to see what we're gonna do with this one? Because I don't want her to say anything on the record by mistake.
Yes, that's fine, Judge. I'll give him a call.
Thank you. I appreciate that.
Thank you.
You're welcome.
Number 26, Mr. Moore. Your Honor, this is a conflict case. She's on there. Oh, okay.
All right, is Miss Watson, you ready?
I am. We're asking to be heard on bond.
Okay, bond only, you're gonna waive arraignment?
Yes, Your Honor.
Thank you. Okay. Mr. Moore, your case is 25 CR 001787C. You're charged with failure to obey a traffic sign and giving false information. You understand your rights?
Yes, ma'am.
All right. Ms. Hardy, can I have the history, please, for position 26?
One moment, please, Your Honor.
Well, it's a status announcement, but if she wants to come to court, she can. So, I mean,
Your Honor, I'm having problems downloading my histories.
I can
Okay,
provide it, Judge.
you have it, Mr. Sirocco. Please proceed.
Yes, Judge. The defendant has 46 cycles. I see a number of convictions. There are giving false information, excuse me. There are roughly 10 or so convictions I have here. The most recent of which were possession of a firearm or knife during commission or attempt to commit certain felonies, receipt, possession, transport, firearm or knife by convicted felon or felony first offender, possession of methamphetamine, 2 counts of that. He was convicted of that in 2022, received a 5-year suspended sentence, convicted of aggravated assault in 2020, convicted of simple battery 2018, convicted of willful obstruction and simple battery in 2017. And I am counting here 3 more willful obstruction of law enforcement officers convictions from 2008 to 04, including that 04 one where there was also a 2 counts of giving false information that he was also convicted of. Presumably open. I see 2 cases. I can't confirm, but I do see arrest for willful obstruction. Oh no, that one's open. 24 SC 001422 is receipt, possession, transport of a firearm by a convicted felon or felony first offender. Another willful obstruction and marijuana possession less than 1 ounce. I also see a terroristic threats and acts, but I don't see that in our system. Additionally, I see an open theft by shoplifting 25 PI 002634 in Superior Court. That is that for the history.
Okay, thank you. Please proceed with your recommendation as it regards to bond.
Yes, Your Honor. We're asking for a signature bond on these charges. He has been
Oh,
in.
not you yet, Ms. Watson.
Oh, I'm sorry.
Let me see what the state's position is, then I'll come
I'm
to
sorry.
you. What is
Thank
the
you, Judge.
current bond?
It's currently a $1,000 good bond.
500 each count?
There are 4 counts here. I can go look up the breakdown.
This is Mr. Moore?
Yes, Your Honor, it's 4 counts, 250
Okay.
per count.
Oh, correct. Okay.
2 are traffic and then the
I see it.
obstruction.
The one is
Okay.
obstruction. Gotcha. Okay. And did I set this bond?
This was Judge Law.
Judge Law set this bond. Okay. All right. And I'm assuming the state wishes the bond to remain as set?
Yes, Judge, given the history here, this nature of the similar offenses, the open cases, including the open willful obstruction, along with the other felony charges or felony charge. The state asks that the bond remain as set. We feel absolutely correct in that this bond should remain a good bond.
Do you want to give me the brief facts of this case?
Absolutely, Judge. This was from April 3rd of 25. The defendant was observed walking southbound on the right shoulder of Georgia 400 towards Holcomb Bridge. And, there's a sign on the entrance ramp to that stating that pedestrians are prohibited from walking there. It's a controlled access highway. When contact was made, defendant provided a fictitious name and date of birth, Jamar Davis, September 22nd, 1985. And upon backup arriving, the defendant actually ran, fleeing eastbound across the lanes of travel, jumping the median wall and continuing east across lanes of travel. He hopped several fences as well. And he again tried to flee, later escape by scaling another fence, running into traffic, putting officer lives in danger, as he has apparently, from his history, no regard for the safety of officers and also motorists on the road. We ask that the bond remain as set.
Okay. All right, Ms. Watson, Cafe, please proceed.
Yeah, Mr. Moore is a lifelong resident of Georgia. Prior to being arrested, he was doing work with ShiftSmart, which is basically an app that allows him to work or pick up gigs at different gas stations, doing custodial work and helping them as needed. He did obtain his GED in 2006. If he again, he does have another a case in Superior Court, which was already discussed. He wouldn't necessarily be getting out if we were to get a signature bond on these charges. But again, based on the amount of the bond, the fact that he's been there since the 2nd, the nature of these charges, his current medical condition, we were asking for a signature bond against that he could be released back to his home. He can continue with his treatment and get back to his family.
How many days has he been in here on this? He's been in 15 days?
The 2nd, Your Honor.
Okay.
Judge, if I could just add that he very well could get out on that felony shoplifting, which is what he's being held on. It's a $1,500 surety. Also, I neglected to include 2 other willful obstruction charges from 2018. I don't have the dispositions for those, but there were 2 other arrests for willful obstruction.
Okay. All right.
FTAs from 23, 18, 2 in 18, and 2 in 2015, and 1 in 2015, excuse me.
Okay.
I don't know about because I represent him in the other case, and I know there were some FTAs that we had cleared up because he was in custody. So I'm not sure if that's what's being as far as the 2018. I represent him on another case in Fulton, and there were FTAs in that case that were cleared. So again, he was in custody. There was basically a mistake.
Okay. I'm gonna convert, I can't convert the obstruction to a signature bond through the jail because it's bond restricted. So for count 1, failure to obey, that'll be a $250 signature bond through the jail. Giving false information, that's a $250 signature bond through the jail. The obstruction is gonna be reduced to a $10 cash bond. And the darting out in traffic is going to be a $250 signature bond to the jail. So he gets a $760 split bond.
Thank you, Your Honor.
Is there anything additional?
Your Honor, how much was the will for instruction?
$10 cash.
Okay, all right, thank you.
All right.
Nothing from this defense, Your Honor.
All right. Anything further from the state?
Nothing from the state, Judge.
All right. Best of luck to you, sir. That concludes this case at this time. Your case will be reset further notice for further development. All right. Miss Watson Cafe, does that conclude your business today?
It does, Your Honor. Thank you.
All right. Take care. Have a good afternoon. Bye-bye.
We're gonna
Judge,
go.
we're ready.
Oh,
Petition
sorry.
number 20C.
Okay, so is Mr. Bartels back? Mr. Bartels,
Yes,
what's the
he
announcement?
went to another courtroom.
Oh, he's not there.
No,
Okay, so who's in the chair at courtroom 2?
number 39 through 41 and add on number 2, Mr. Turner.
Okay, I didn't have the add-on.
Well, actually, those cases at add-on is listed in a tiny notes instead of the.
Okay, inside of it, I see it. Okay. So, Mr. Turner, and the announcement I have is that this case is gonna be a plea as well?
Yes, Your Honor.
Okay. So, Mr. Turner, you have several cases that we are addressing today. Your case is 25 CR 001979Y. You're charged with criminal trespass. You also have 25 CR 001908Y. I'm sorry, 80Y. You're charged with criminal trespass in that case. And then 25 CR 001981Y. You're charged with theft by shoplifting in that case. And I'm missing. What case am I missing? What case number am I missing? See, hold on. I think that's all 3. Is there a 4th case?
The add-on is criminal trespass. The position 39 is criminal trespass and willful obstruction. Position 40 is criminal trespass, and position 41 is theft by shoplifting.
Okay. You understand your rights today and what you're charged with, Mr. Turner?
Yes, ma'am.
All right, making sure we're all on the same page. And Mr. Sirocco, I know he has a lot of cases, but if you wouldn't mind giving us still some brief facts and putting the recommendation onto the record.
Sure thing, Judge. So the state's recommendation here I'm going to begin with the add-on. It's for 25 CR 001734Y. 12 months to serve 48 days, credit for time served 24 days. And that is from April 1st of this year to present, balance probated, 40 hours of community service, no further contact with Joshua Walton. That's spelled Joshwa, Walton, and stay away from 370 Peachtree Hills Avenue, Northeast Atlanta. With respect to it's the criminal trespass, willful obstruction, position 39, 12 months probation, concurrent with count 2, stay away from the QT gas station at 761 Sidney Marcus Boulevard, Northeast in Atlanta. And on count 2, the willful obstruction, 12 months probation, concurrent with 25 CR 001734Y, a $300 fine, and an Op 21 law and decision-making course. On position 40, 25 CR 001980Y. That's the criminal trespass, 12 months probation, concurrent with 25 CR 001734Y. BHET, stay away from Willie's Mexican Restaurant at 1100 Hammond Drive in Sandy Springs. And on the final case there, 25 CR 001981Y, theft by shoplifting, 12 months probation, concurrent with 25 CR 001734Y. Anti-theft course, restitution to Publix open for 30 days, and stay away from all Publix premises and property. I'll try and make these as brief as I can, but I'm going to start with the latest criminal trespass, and we'll move our way back to the beginning. April 1st is when this occurred of this year. 370 Peachtree Hills Avenue in Atlanta. It's the Peachtree Hill Court apartment complex. Law enforcement made contact with defendant after receiving a criminal trespass call. He was sitting on the stairwell of the residence of Mr. Joshua Walton. He had been given a copy of charges on the previous day for public indecency and had returned to the location, was given a criminal trespass warning. And then despite that previous warning, he returned again and remained on the property. With respect to the criminal trespass and willful obstruction for position 39, that took place February 21st of 2024 at 761 Sidney Marcus Boulevard in Atlanta. It's the QT gas station there. Defendant had been told not to return to the location just a few hours ago by QT employees and an APD officer, but hours later he returned anyways. And while the officer was speaking with the defendant and the manager, the officer advised that, you know, the defendant's not free to leave. The defendant stated that he was free to leave and then began to attempt to flee. After a bike chase, the defendant was ultimately detained. And with respect to position 40, the criminal trespass, that incident took place June 30th, 2024 at 1100 Hammond Drive in Sandy Springs, Willie's Mexican restaurant. Law enforcement responded to a disorderly person call. He was loud and belligerent. He was asked to leave by restaurant staff, and was, you know, on account of him yelling and cursing at staff and other patrons. He refused to do so, and he was ultimately placed under arrest. The last position, position 41, is the theft by shoplifting, and that took place August 28th, 2024 at the Publix located at 1100 Hammond Drive in Sandy Springs. Law enforcement responded to a shoplifting call, and the store manager, Miss Lisa Riddle, that's Riddle, explained that a man later identified as the defendant had been entering the door and had been stealing items, and that on August 28th, he had come back, that same individual, grabbed items off the shelf, left without paying. Total value, roughly $100, is what it was estimated to be at. He was later identified and arrested the same day. We would sound for Mr. Joshua Walton if he is on the line. And we ask the defense to stipulate the factual basis, venue, and ID for purposes of the plea.
All right, is Mr. Walton present and wishes to make a brief statement? Hearing none, Ms. Kim, do you so stipulate?
Your Honor, we would like to request that $300 fine to be transferred to, converted to 30 hours of community service. He is currently unemployed, and the restitution to Publix open for 30 days. We would like to object because it has been more than like 10 months and there has been no responses from Publix. I think it is kind of a little too remote and a little late for them to bring it up as of now. And also, we asked for 2 months of probation fee waived so that way he can get his job to start paying for anti-theft course and continue with his probation. We would like to request the probation to be terminated upon the completion of all these conditions.
Okay, any thoughts, Mr. Sirocco, on any things that Ms. Kim has requested of the court?
Yes, Judge. We would object to probation terminating. First, you know, just there's a history of criminal trespass here, actually a really, honestly, recent history, several convictions for criminal trespass in 2024. Like I'm counting 3, including a disorderly conduct and criminal trespass and resisting, obstructing, opposing law enforcement on duty with an animal or human bodily fluids. The state would object. There's just a lot of criminal trespasses here. And I just want to put on the record that $300 fine is statutorily required. Let's see. Beyond that, I mean, just the number of cases here, probation should remain. Thank you.
Okay. Okay, I am gonna convert that fine to 30 hours community service. I'm going to strike the restitution open. I agree with the defense there. And I am gonna say that once he completes the requirements, it can go non-reporting. However, it won't terminate. And then I will waive 2 months of fees, okay? So does your client wish to go forward with the plea?
Yes, Your Honor.
All right, please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge and is given under the penalty of perjury?
Yes, Your Honor.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol that would affect your ability to understand this proceeding today?
No, Your Honor.
Did anyone force you to take a plea?
No, Your Honor.
Did anyone promise you anything in exchange for taking a plea?
No, Your Honor.
And you fully understand all the requirements as explained to you by your attorney, including the community service, the courses, and all the locations that you have to stay away from?
Yes, Your Honor.
Are you satisfied with Ms. Kim's representation?
Absolutely, Your Honor.
And you understand that you are giving up your right to trial by judge or by jury?
Yes, Your Honor.
And you further understand the state no longer has to prove this case beyond a reasonable doubt?
Yes, Your Honor.
And you understand that taking a guilty plea can affect other aspects of your life, such as probation, employment, or immigration, things of that nature?
Yes, Your Honor.
All right, as to the charges previously listed by both the state and myself, how do you plead, Mr. Turner?
Guilty, Your Honor.
I accept your guilty plea at this time. Is there anything additional?
Nothing further from the defense, Your Honor. We stipulate for the purpose of the plea.
Nothing from the state, Judge.
All right. And let me make sure, did I sound for Mr. Walton? I believe I did. All right.
If not, we could do so.
Yeah. I don't see him and I've sounded. All right. Best of luck to you, sir. That concludes your case at this time. All right. Can we go? Is Mr. Bartels back? Can we go back to position 20?
No, he stepped out again, but we can do position 30 and 31, Parker.
Okay. I have that this is a negotiated plea. Is that correct? You're muted, Ms. Kim.
I'm sorry, let's do Mr. Harris, Tyrone Harris.
Oh, Mr. Harris. That's number 16.
Yes.
And okay, hold on. I had that 16 is Mr. Howard. I'm sorry, this is
Tyrone Harris.
that's not on my calendar. What number? Does anybody see that one?
Tyrone Harris
He's
is
on
on the
the-
add-on calendar, Your Honor. I did
Oh,
do the add-on calendar.
okay.
I'm sorry.
That's okay. Hold on. Let me pull it up very
And
quickly.
Judge, he's
Yep.
declined our services.
Okay, understood.
And Your Honor, we asked that the court address this case because it was a reset jail jury, and the case had not been addressed. So we asked to have it brought back to address it.
It was reset jail jury from SAP before?
Correct, in January of 2025. Which is
And
why
it-
which was why we brought it back.
And it didn't make it to the division? I'm just confused what happened.
It
Okay, I
went
guess.
to the division. It did go to the division. The defendant had plea and arraignment February 19th of 2025.
And it's back here.
Right. The arraignment was before Judge Mather. And the case is in Judge Mather's courtroom.
Okay, I'm just confused why it's back to me, Ms. Falk. Maybe help me here.
So the defendant has now been in jail for let's see, just to pull this up for Your Honor.
I got it, 121 days at
That is
least.
correct, on a criminal trespass.
Okay.
And the state just wanted to give the defendant an opportunity, if he wished to enter a plea, to enter one.
I doubt that's gonna happen. All right, Mr.
I
Harris.
understand.
Your case is 24 CR 008301G. You're charged for criminal trespass in this case. I understand that you have declined the services of the Public Defender's Office. It's my recommendation that you allow them to assist you today. Do you still wish to represent yourself?
Yes, ma'am.
All right. I'm gonna allow Ms. Falk to put the offer to resolve this case onto the record today to see if you wish to plead guilty. So we're gonna go forward with that. But first, do you understand, you do fully understand your rights today, including the right to an attorney?
Yes, ma'am.
Okay. All right, Ms. Falk, the offer in this case is?
The offer is time served, Your Honor, which would release him effective today. The state's recommendation is based on the fact that the defendant has been in custody for 121 days. This incident happened December 25th of 2024 at the Greyhound bus station at 232 Forsyth Street Southwest in Atlanta. The defendant officers were called out to that location because the security guard had asked the defendant to leave several times. He refused. He stated he was a sovereign citizen, did not need to leave, and the officers, after asking several times, finally took him into custody.
Understood. Okay, so Mr. Howard, do you wish to take a plea today to resolve the case? The state is essentially offering to close the case based upon the time you served in the Fulton County Jail. However, they are asking you to plead guilty, and there were certain questions and representations you'd have to make to do so. How do you wish to resolve your case today?
I'll plead guilty. That's
You would
fine.
like to plead guilty?
Yeah, it wouldn't matter on either way, correct? If I did not plead guilty, like the first trial, pre-trial.
Okay, I'm gonna ask you some questions. I'm gonna place you under oath. Please raise your right hand. Do you affirm that the testimony you give today be the truth to the best of your knowledge?
Yes, ma'am.
All right. All right. I'm gonna have to ask you some additional questions because you're representing yourself. Again, you are declining the services of the Public Defender's Office. Do you wish to have their assistance? I recommend that you take it.
I mean, I have paperwork showing, proving my, sovereignty now, but I mean, if it doesn't go, towards the jurisdiction, I'll just, go with best option.
Okay, so the answer is no, you don't want them to help you.
So, ma'am.
Okay. Do you agree that the state has the proper defendant, being you in this case?
Yes, ma'am.
Do you agree that this took place in Fulton County?
Yes, ma'am.
And do you stipulate or in a sense agree that the facts that's just put on the record are what happened that day? You may disagree slightly, but for the purposes of this plea, do you agree that that's what happened?
Yes, ma'am. And I had, for that day, I had a compensation, on courtesy, transportation, not by just the officer that didn't arrest me. It was another officer that took me in and said he was gonna pay for my, bus ticket, but also the bus driver, for helping out, one of the, people on the bus, giving up my seat and everything of that nature.
Okay. Are you under the influence of any drugs or alcohol that would affect your ability to understand this proceeding today?
No, ma'am, I don't smoke or drink. If I'm
Okay.
out, I drink wine, but that's it.
All right. Did anyone promise you anything in exchange for taking a plea?
No, not at all.
Okay. And you don't feel forced to take a plea today, do you?
No, I'm not forced at all.
Okay. And you again are declining the services of an attorney, even though you understand that you have a right to an attorney at this proceeding.
Yep.
And you understand that you're giving up your right to trial as it pertains to this matter?
Yep, ain't no point in going to trial for criminal trespassing if I already time served. So,
Okay. And you're giving up your right to have the state prove this charge against you beyond a reasonable doubt?
no, ma'am, I ain't get up no rights.
Oh, if you would have to give up your right to take a plea. If you don't want to take a plea and we proceed to trial, essentially I'm asking if you still want a trial. Do you still want a trial on this?
No, I'll plead guilty. Go ahead, I'm fine with that. I'll do fine.
Okay. And you understand that taking a guilty plea may affect other aspects of your life, such as an open case if you have one, any probation issues, anything of that nature?
No, ma'am.
You don't understand that?
No, I understand it. I'm agreeing with you.
Okay. All right. As to the charge of criminal trespass, Mr. Harris, how do you plead?
Guilty.
I accept your guilty plea. Is there anything additional, Ms. Falk?
No, Your Honor.
All right. Essentially, the time you've served in the Fulton County Jail should close your case. All right. Best of luck to you, Mr. Harris.
I'm saying I get all my information.
Okay, and will somebody at the jail be able to help him sign the paperwork? I'm not sure who, but it was somebody, because he won't be able to get out if we don't have any documents.
31.
Doug, we're ready for position number 20, Lee.
Okay. Mr. Bartels, you ready for Lee?
I can address that case, Your Honor.
All right, what is
You're
the announcement? I'm sorry, go ahead, Ms. Falk.
I would just ask if we could do 30 and 31 first while I'm filling out this paperwork to send over to the jail on Mr. Harris.
Okay, well, Ms. Falk needs a minute before we can do Ms. Lee. So we'll go back to 30 and 31.
How you doing?
All right, the announcement I have is that this is a plea.
Yes, Your Honor.
Okay. All right, Mr. Parker, your case is 24 CR 006424E, in which you're charged with DUI, and you also have an FTA. Do you understand your rights today? You have a right to remain silent, and you have a right to an attorney. Do you understand that today?
Oh, Your Honor, he changed his mind now. Please have a 1 minute with him. I apologize.
Okay, in the meantime, Mr. Bartels, what is your announcement? Are we taking a plea for Ms. Lee, or do you have an announcement for Ms. Lee?
Well, Your Honor, I have spoken with Ms. Lee again about her options and let her know what the questions are that would need to be answered if a guilty plea is to be accepted by this court. I don't have an indication what she wants to do, so perhaps it could be reset so that a social worker could talk with her.
Okay.
Ms. Burgess is here and she's volunteered to see Ms. Lee.
Okay, so you're asking for a 1 week reset for a social worker visit?
Yes, Your Honor. It could be either the 9 a.m. or 11 a.m. calendar. I can't say which.
It has to go to 9 for now, and then if we have other development, it'll go later. Okay, so we're gonna reset. Miss Lee, a social worker from the public defender's office is gonna come and speak to you and figure out what direction to take your case. Okay, so we're gonna reset your case 1 week to see if there's some development we can take between now and then. Miss Lee does have a bond though, correct?
That's correct, Your Honor.
All right, so there is a bond on your case, okay? I just wanted to make you aware, but someone will be coming to see you, Miss Lee, in the Fulton County Jail, okay?
Thank you, Your Honor.
All right, you're free to go, and that case is closed now. Ms. Falk, you wanted to make a statement?
Just courtroom 2, is there a deputy that I can send this paperwork to? I just need a last name. I don't need first name.
Yes. Send it to Sergeant R. Blanton.
Blanton. Okay, got it. Thank you.
So, Your Honor, for 31 and 30, he pleads not guilty, and I'll file waiver of arraignment paper.
Okay, not guilty for Mr. Parker. Does he wish to be heard on bond or no?
I believe he already has a bond, Your Honor.
Okay, so we'll go with that then.
Yes.
All right, Mr. Parker, your case will be reset while your attorney does some additional development. They're going to enter the forms to indicate that you're pleading not guilty at this time, okay?
Thank you, Your Honor.
Thank you. You're free to go. All right, who do we have next?
Number 35, Simpson.
Thought we already addressed Stinson.
No.
This is Simpson.
Oh, Simpson. Okay, thank you.
And that announcement is that this is a negotiated plea?
Yes, Your Honor.
Okay. All right, Mr. Simpson, your case is 25 CR 001884E. You're charged with criminal trespass and obstruction. Do you understand your rights today?
Yes, Your Honor.
All right, and Ms. Falk, if you would please, oh, I'm sorry, Mr. Sirocco, please proceed.
Thank you, Judge. Yes, the state's recommendation is for count 1, the criminal trespass, 12 months to serve, 32 days, credit for time served, 16 days. That is from April 9th of 2025 to present. Balance probated, BHET, stay away from Manchester Ridge Apartments at 3110 Godby Road in College Park. No further contact with the Miss Princess Pepra, Princess, Peprah, and 40 hours of community service. As for count 2, the willful obstruction, 12 months probation concurrent with count 1 and a $300 fine. This incident took place April 8th of this year at 3110 Godby Road, which is the Manchester Ridge Apartments in College Park. There was an individual who had been reported, a male living inside a vacant unit there, Unit 2D, who had provided, and the Miss Pepra explained, she's the leasing agent there, explained that that unit had been vacant since October 29th, 2024. And they were able to confirm that there was video footage of the subject, later identified as the defendant, provided to law enforcement. And while patrolling the area around that evening, the officer observed a male from the video heading towards 3110 Godby Road, who identified himself as the defendant when the officer made contact. And he had claimed his name was on the lease, but it was confirmed again that the system did not show the defendant's name anywhere on the lease of the property. And when the officer attempted to place the defendant under arrest, he resisted and tried to flee and refused to allow officers to place him into handcuffs. So that is that. We would sound for Miss Princess Pepra if she happens to be on the line, but we asked the defense to stipulate to venue, factual basis, and ID for purposes of the plea.
All right, is Miss Princess Pepper on the line and wishes to make a brief statement? Hearing none, Miss Kim?
Yes, we would like to request that probation to be terminated upon the completion of the conditions, Your Honor.
Judge, I am going to object to that. Briefly, he was arrested for burglary in 2025, and he was found in his underwear in the bed of a woman's residence where he did not live. That location being 2135 Godby Road in College Park, which is just down the road from the incident location. Now, that was ultimately DWAP'd, but he was convicted of stalking, terroristic threats and acts, and loiter prowl. That involved him repeatedly knocking on the door of the woman whose residence he had entered previously because he blamed her for the arrest and threatened to beat her. Given that, we don't want anything similar happening here. We think that this needs to be the balance needs to be probated. So we would object to that.
Okay, it's not going to terminate, Miss Kim. But I do need you to stipulate. Do you stipulate to the 3 elements?
Yes, we do.
All right, and your client wishes to move forward and take this plea at this time?
Yes, he does.
All right, please raise your right hand. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge and is given under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time that would affect your ability to understand this proceeding?
No, Your Honor.
Did anyone promise you anything in exchange for taking a plea today?
No, Your Honor.
Did anyone force or coerce you into taking a plea?
No, Your Honor.
And you understand by taking a plea today, you're giving up your right to trial by judge or jury?
Yes, Your Honor.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes.
All right, and you further understand the requirements that you're going to undergo some evaluations. You are going to stay away from that location on Godby Road and have no contact with Ms. Pepra. You're also going to complete 40 hours of community service and pay a fine. Do you understand all of that, Mr. Simpson?
Yes, Your Honor.
As to the charges of criminal trespass and obstruction, how do you plead?
Guilty.
I accept your guilty plea at this time. Anything additional from state or defense?
Nothing from defense, Your Honor.
All right,
Thank you, Judge. Thank you.
best of luck to you, sir. That concludes your case. Does this conclude the entire calendar?
Your Honor, may I address the court?
I'm sorry, who's speaking?
Amoy White.
And
For Gary White. Gary was supposed to be on the calendar today, I was told.
okay, hold 1 second.
Yes,
He's on
ma'am.
the add-on, Your Honor.
He's okay. Are we gonna address that case today? Let me look and see. Hold on.
The way I understood was it was gonna be reset to next week because he is still searching for placement.
Okay, so we will not be addressing that case today, Miss White. We're gonna reset it 1 week if you want to come back at that time.
Okay, is the same link or what day of next week?
It should be this same time next Thursday. It's a different link.
It's the same link.
Oh, it's the same link. You can follow the same link.
Okay, next Thursday at 9?
Yes.
Okay, thank you.
All right.
And-
Go ahead, Ms.
Sorry,
Hall.
Your Honor, just to ask courtroom two, has anyone been able to reach out to the social worker working on his case? Because it was reset from SEA because of placement issues.
Right, actually, Ms. Keisha is working on it. And I emailed her and I also spoke with PD Mike. We still need to, it's still in the process.
Okay.
There she is.
Okay.
So I have
Joanna.
right now, as I've been told, is the housing that has been identified, Diamonds in the Rough. They're waiting on some type of number to get authorization to house Mr. White in the placement there.
Oh, I remember
That's
this
where we're
case
at
now.
with that.
Right.
And
I
he
remember
says
it
that
now.
that can take about 3 months to a year.
3 months to a year.
That is what he told me that process can take. So I'm not sure how else.
Is there any other placement that's possible? No.
3 months to a
I
year.
believe his caseworker is on the line and can help us out with that part.
Okay, let's hold on all this for 1 second. It's not like this is
Yeah,
gonna take
sure.
a second. Are there other matters that we have not resolved today? Other cases at courtroom 2?
I just have one announcement to make, Your Honor. Just a heads up on number 42, Ms. Turner. She is set to be released to a placement on Monday. We've already had the bond order. Mr. Jordan got that signed and filed. However, I made one error. I put the incorrect last name for the person to whom she's supposed to be released. I do apologize. But I can get an amended order with the correct name today. All the other requirements or conditions are going to be the same. And I believe the pharmacy is already getting together her medications.
That's fine. If you want to send an amended order on 42, I can sign.
All right, thank you, Judge. I apologize.
All right, we'll come back to Mr. White in a minute. There was another case on the add-on that I didn't have an announcement for. I think it was is that the same person? No, that's a
Yes,
different
Your
person.
Honor, that was
It's the same
that was the
person.
other part of Mr. Turner. Is that who you're referring to?
Yes.
That was part of his other
That's the
cases
same
that were
cases. Okay.
addressed. Mhm.
So is SAP complete? Are we ready to review and then discuss Mr. White in the other calendars? All right, I believe SAP is complete. Mr. Jordan, will you review this calendar for us?
Position 1, can everybody hear me?
Yes.
Position 1, waive jury. Position 2 was a amended bond, $6,000 total surety, $2,500 for count 1,
Your Honor,
1,000 for count 2, and $2,500 surety for count 3.
sorry to interrupt. On position 2, technically was an amended order. It was just, he was just given
Oh, he
bond.
never had a bond. I got you.
Right.
Thank you.
Do I need to send you a bond order, or since it's not amended, or not?
Yes, please send a bond order.
No worries. Got it.
Okay, thank you. Position 3 was a plea. Position 4 Can we do
Your
this
Honor,
too?
that will need to be reset 1 week. We need to make a recommendation on that case. The DA's office determined that even though there are 3 or more prior theft by shoplifting convictions, they have declined to take the case, while
Okay, so,
acknowledging that it is in fact a recidivist.
well, they don't want it. You can't make them take it. So, okay. And there's no offer today? I'm assuming no. So we
I
have
do
to,
not, I just got that email about 30, 40 minutes ago. So no.
okay. Reset Carter 1 week. Thank you, Ms. Falk.
Position 5 is reset 5/125 SAP. Position 6 was a plea. Position 7 waived jury, amended bond. Count 1 was a $80 cash bond. Count 2 and 3 were $500 sign-on bond jail. Total of $1,080 split bond. Position 8 waived jury. Position 9 was release. Position 10 was a plea. Position 11 was a plea. Position 12 was reset 5/125 SAP. Position 13 is waived jury. Position 14 was a plea. Position 15 was a NOLO plea. Judge, one quick question. Was that probation non-reporting upon completion on those 2 cases?
I'm sorry, what number was that?
Positions 14 and 15?
Yes, I think he could go non-reporting. It's not going to terminate.
Okay, thank you. Position 16 was released. Position 17 waived jury. Position 18 and 19 waived jury. Position 20 is reset 5/125 SAP. Position 21 was a plea. Position 22 is a no pros. Position 23 is reset 5/125 SAP. Position 24 made bond, 24 and 25. Position 26 waived jury with an amended bond order. Total $760 split bond. $250 sign-on bond jail for counts 1, 2, and 4. $10 cash on count 3. What was the announcement for 27 and 28?
We are
Oh.
going to ask to reset that to 5/1 SAP. The DA's office has not made a determination on that case yet.
Thank you. Position 29 was a plea. Position 30 and 31 waived jury. Position 32, what was the announcement for 32?
The DA's office has accepted this case as a transfer. I don't know the difference between this case and the other theft by shoplifting recidivist, but they are accepting this. So I will send the order.
Same with positions 33 and 34? They were pending
33, they did not accept. Again, there is no notable difference between the two. They just declined to accept it.
We said 5/25, 5/125.
Yep. So we can come up with a recommendation.
Thank you. Position 35 was a plea. Position 36 was released. Position 37 was a plea. Position 38 waived jury. Position 39, also position 40 and 41, and position 2 on the add-on was a plea. Position 42 is reset 5125 SA plea. Position 43 waived jury. Reset 5125 SAP for a status. Position 44 made bond. Position 1 on the add-on calendar was a plea. And position 3 is reset 5125 for status.
Any comments, changes, corrections, questions? Okay. Okay. Mr. White technically is not on our 11, so we can discuss it. I know he's the gentleman that has the signature bond, but was supposed to go to that location. That location logged on last time and indicated that they needed to meet him before they said they could take him. And I had offered to do the order in the interim if he made that determination between now and SAP. And now it seems like they're not going to be able to make that determination for several weeks. So does he need another placement explored? Is Mr. Bartel
Yes.
still there?
Your Honor, may I address? This is his mother.
Hold 1 second.
Okay.
Any thoughts on what else we're going to do?
I would have to work with his caseworker. I believe she's on, just to see where she's at, or if it's just a matter of doing Diamonds of the Rough with Mr. White.
I'm sorry, it was Miss Warfield? Was that the
Yes.
Yes.
Miss Warfield, I spoke with you last time,
Mm-hmm.
and it sounds like this is not going to be a quick or immediate placement for Mr. White. So, what are the thoughts about his release and placement from here?
Well, at the moment, there is no other place to put him at right now. Initially, Diamonds in the Rough did have a location, but due to the steps and his mobility, that wasn't a feasible place for him. So right now, we're just waiting to hear from the region. We just need this. We finally got the reference number. So now we need the site number, and it's just waiting on the region to give them the okay for him to move in. My hands are tied, and there is no emergency respite available right now for Mr. Gary. What about crisis? There's no crisis resources? Not at this
It
time.
doesn't sound like it.
Mm-mm.
Okay. So we're all at a loss for what to do. Okay, I guess we keep resetting Mr. White. I can't think of anything else. If there's no other place to take him and we have to wait for Diamonds in the Rough to complete their evaluation, I don't see any other options. Does anyone else have thoughts or wish to weigh in? Miss White, I'll hear from you, but again, it sounds like there's nothing they can do. But go ahead.
Yeah, that's what I was gonna ask. I mean, it's near nothing to expedite the regions. It shouldn't take them that long to provide a number, and they should support Gary as far as at least get him a hotel with someone to sit with them instead of having him there. I mean, that's not fair to him. The regions is it's a wide thing. They have Macon, they have all over. I don't think they're putting enough effort to really get him out of there.
I will say, Your Honor, Mr. McLean had reached out to me earlier in the week indicating that Miss White may be able to take her son and asking me to modify the bond to reflect that, but then the bond modification wasn't signed for some reason. So is that still an option, Miss White?
So no. So what happened at the time, yes, I was thinking about it, but when I think, further, I'm like, how am I going to manage? Because the reason why he's not with me is because I was not able to manage and support him emotionally. I work 7 days a week with children, and for him to try to elope all the time, he went to the regions before, and they weren't taking care of the home that he was in, and I took him home,
And it took like a year and a half for them to remove him from me. And it was terrible. I mean, he broke his leg from running away, just constantly does not want to stay with me. And so that's just, it takes so much out of me to try to keep him in. And now it just hurts to know that I can't help and he's after going to be in there for at least a year. I don't know which one hurts more because I just can't support him. Taking care of him, I was literally on medication because anxiety from, just him eloping all the time, and I just can't. I was supporting him when he was in the group home. I make sure that he has snacks for a month, at a time. Load up his card with money, just support him other from the outside. But to have him here, I mean, I've known my mom is in the emergency. She's 85. I have a 15-year-old that's not listening. I mean, it's too much for me. I can't.
Yeah, yes, ma'am. I completely understand. I apologize. I just was wondering if there was that as an option. So, but I completely understand.
Yes.
I was trying to look up something myself, and I don't think that's going to be an option either. I don't know what to do other than to keep resetting this case to check on it.
Your Honor, we just keep in mind that he's in the medical unit laying on a cot
Right.
on the floor.
And Your Honor, Gary, he doesn't know how to put his clothes on, and that's a concern for me because you have all prisoners calling me, and they have to help him get dressed and all of that, and that just bothers me. He's not supposed to be there. He's vulnerable.
Your Honor, could we, myself, the PD's office, Ms. Kasha, and Your Honor, just have a very brief breakout?
Sure.
Okay.
Ms. Falk, who you want in there?
Judge Williams, the PD social worker Kasha, and PD Kim, please.
Can I be placed in there as well?
And ASG Sirocco, I apologize. I'm going to have to keep you out on this one.
You say you don't want him in?
Yes, Miss Grace, I do not want ASG Sirocco in.
Okay.
Just the four of us, if you don't mind. Nothing to do with Mr. Sirocco. He's a lovely person.
No, we know. I understand. I'm sure he's not offended. Okay, we are back on the record for Mr. White's case after some discussion. The case is going to be reset 1 week, but we believe that after reviewing the file, the case will be null pros. There's some additional development that needs to be done, but we believe it will be null pros next Thursday. That means that next Thursday, Mr. White will be released from the Fulton County Jail. Ms. Warfield, are you on the line?
Yes, I am.
Okay, so basically what we're going to look at this matter a little bit closely, but more than likely the state will not be moving forward with this case, and he will not be able to stay in the Fulton County Jail past next Thursday. So I don't know where that leaves him, but the state there won't, if there's no case pending against him, the jail will be releasing him. Okay?
Okay.
All right, so Mr. White is reset 1 week SAP, and at that time, Ms. Falk will do some research between now and then.
Yes, Your Honor.
All
What's the
right.
date?
Thank you.
Excuse me.
I'm
The
sorry, go
date-
ahead.
what's
May
the-
1st, we're 90% sure he will be, more than 90, pretty sure that he will be released next Thursday, as there is likely to be no case pending to hold him in the Fulton County Jail.
Gotcha.
That is correct, Your Honor. The state just needs to do a little bit more looking into this, but I can almost guarantee we will be releasing him May 1st.
May 1st. All right, thank you.
All right, Mr. White's case is now closed. SAP is complete. Those who do not need to be here for either of the 11 o'clock calendars are free to go, but we are going to take a very short 10-minute break before we resume. So everybody else who doesn't need to be here for the 11 a.m. calendars can be free to take lunch and leave. Thank you all.
Thank you. Bye-bye.
I'm sorry, Ms. Greenhouse, you had a question. Are we taking any, let me ask that. Mr. Bartels, are we taking any pleas? Is Mr. Bartels still there? Ms. Kim, do you know, are we taking any pleas at the 11 o'clock?
Your Honor, there is one plea we'll offer for the court. Mr. Sperling, it's not an extra time plea, it's just credit for time served in probation.
Okay, so will we need Ms. Greenhouse?
I was
Probably.
go to a breakout room with Miss Dashawn Woods for a bench warrant case.
Oh, okay. So we might, Ms. Greenhouse, would you mind giving us a few minutes in the event
No,
that
of
we
course
take?
not.
So we
Glad to-
might, thank you. So we may take a plea on that 11 o'clock case. Can Ms. Kim speak with the is Ms. Woods on the line? Or is it Miss Woods? Can Miss Woods be placed in a
Yes, I'm on
breakout, Ms. Kim?
Yes, I'm on the line.
All right, so let's put them in a breakout. And Ms. Falk, if there's an offer, will you send that over to Ms. Kim?
I believe she already has it as part of the information I sent over.
Okay, so we'll be back at 11:40. Thank you all for your patience.
Yeah, I thought we were gonna go ahead. Okay, we'll go ahead and do that when the judge gets back on, okay?
Am I able to speak with Miss Kim or get a contact information from Miss Kim? I
We're gonna put
probably
you in a
messaged
breakout
you in
room.
the chat.
Would you please?
We're gonna put you in a breakout room.
All right, I'm back. This courtroom too.
But they're still in the breakout room for the,
Oh,
TV.
can they come back? Oh, they're still talking about Miss Kim is speaking with the 11 o'clock lady. Okay. Okay. We'll hold. All right, we're gonna is Miss Woods out of the breakout?
She was coming out, Your Honor, so she should be here.
All right, Miss Woods, we need you to turn on your camera, please.
It's not allowing me to turn my camera on.
You're gonna have to figure it out, or else it's as if you weren't here today.
Okay, there we go. Here, I'm sorry.
Okay, Miss Woods, I'm gonna have to ask you, can you please remove your scarf? You are in court.
Yes,
Okay.
ma'am.
All right, and all right.
Okay, I'm sorry.
Let's commence the DV bench warrant calendar. This calendar is for those individuals who have failed to appear for a calendar for a previously scheduled hearing in a domestic violence related case, and there is currently a bench warrant pending from their arrest. Ms. Woods, I'm going to hear from the state and from your attorney about how their positions at this time. And before we do any of that, Ms. Falk, will you put the current offer onto the record?
Yes, Your Honor. The state's current offer on this case is 12 months served, 30 days, credit for time served, 5 days, from November 30th, 2023 to December 4th, 2023, balance probated FVIP, 40 hours of community service, and no further contact with Titus Williams, count 2, 12 months concurrent to count 1 with a parenting course.
Okay. Miss Kim, I assume that you presented that to your client and that was it rejected, accepted, or what is your client's position?
It was rejected, Your Honor.
Okay. Let me read you your rights, Miss Woods. Your case is 23 CR 007632A. In this case, you are charged with battery, family violence, and cruelty to children in the third degree with the offense date, of May the 9th of 2023. Apparently, at some point, there was a hearing that you missed. All right, the offer is rejected, so let's hear the state's position regarding the dismissal or removal of the bench warrant at this time.
Yes, Your Honor. So the defendant failed to appear on a final plea calendar that was before Judge Roth on April 3rd, 2025. There was no return to sender notice on file, so it did not appear that she had changed her address or something else had happened to cause it to bounce back. We will say that the defendant appears to also have a warrant outstanding from the Georgia Tech Police Department that was dated October 11th, 2024. That's what came up on when we ran her information on March 3rd, 2025. For that reason, we are asking that the bench warrant be enforced. Additionally, the defendant has FTAs from 2010, 2012, 2014, 2015, and 2018, which again is a basis for the state asking that the bench warrant be enforced. This is not her first rodeo. She's used to having to come to court, and apparently 5 separate occasions she has failed to appear.
No, I have not, ma'am.
No, hold, Miss Woods. Okay. All right, Miss Kim, would you like to give us some indication as to what it was an April 5th final plea?
Yes.
April 3rd, Your Honor.
April 3rd final plea.
Yes, Your Honor.
All right, Miss Kim, would you like to give us some information regarding your client's failure to appear that day?
Yes, Your Honor. My client never received any notice of hearing. Apparently, when she was leaving the jail on May 29, 2023, she actually gave a correct address, 1350 Mason Tunnel Road. However, it was never changed, and the jail actually put the address from her ID, which was the old address, and that's where the mail was sent out. She has lived in a new place ever since April 20, 2022. So she gave the correct address on May 29, 2023 to the jail and clerk at the jail. However, it was not reflected, Your Honor. And we would like to request for just one-time courtesy set aside for the bench warrant. She said she never had any FTA before, and I didn't know there was any 5 separate FTAs in the past. So I was hoping to get this set aside for the benefit of doubt.
So this was a final plea, so she made it to all the other hearings. I'm assuming.
Yeah, she made a lot of hearings, Your Honor. That was the only one that was missing from this court.
Right, Your Honor. There was a waiver of arraignment not guilty entered May 13th of 2024. And then it was then brought back for this calendar because she failed to appear. So I'm not sure if she actually appeared on May 13th of 2024 or
somebody waived her arraignment.
The attorney that I spoke with, I don't remember her name. She waived it and she told me that I did not have to appear. And she told me that it would be another court date that came up. And like I said, I never received it because I'm not trying to run from this. I'm a stay-at-home mom of 4 kids. My husband was just in a bike accident last night. So I stay at home while he works. So I'm trying to get this stuff resolved so that I can be able to go to work and take care of my kids. I have 4 kids under the age of 10, and I've been at home trying to take care of this. And for the Georgia Tech, I'm waiting to go to court on that case.
You have a right to remain silent. We don't have to bring up any other case, which is not relevant to this case. I just wanted to let you know you have a right to remain silent.
Yeah, don't say too much about the other matter. Okay. I want to look at one thing myself. Give me one moment. Okay, here's what we're gonna do. Hold on. Nope, that's not it.
Can I say one thing, Judge?
I don't think you should, Miss Woods, because again, Miss Falk is listening, and she could decide to add additional charges. Sometimes people say things that they think are helping them, and then it turns out not to. But I think you should avail yourself of your right to remain silent. But what is it you'd like to tell me, very briefly, that does not get
This
into?
man is still coming around my house. Titus Williams is still randomly popping up at my house, and I'm trying to get this.
Yeah, I don't think you should tell me that. Okay, you should speak to someone. You can speak to Miss Kim about that. Okay.
Crazy, man. I can't even defend myself.
Please be able to remain.
Okay, what we're gonna do is I will set aside the bench warrant this one time as a courtesy, and it is against my better judgment in light. The defendant does seem to have some indication of understanding the court process. Ma'am, I am giving you a second chance here to clear this up. Within 72 hours, you need to come down to the Fulton County Courthouse and give them an updated address to send this. You need to check weekly on this case because a second set aside will not happen should you miss another court date. Do you understand that? Can we unmute her? Can you unmute? Do you understand that, Ms. Woods? This is
Yes,
a
ma'am. So
one-time.
I need to come down where to update
You
my
need to come.
address?
Where can she update it at J150, Mr. Jordan?
Yes,
This
ma'am.
Okay, so you need to come down to the Fulton County Courthouse on Pryor Street. Go to J150 and give them and ask for an update or a change of address
it's
form.
right here.
I can't see it. You need to take it down there, okay?
Your Honor, actually, the system already has a new address.
Is it the correct address?
Yes, Your Honor.
That looks like it was done in the clerk's office, so I'll check to make sure we have the correct address.
Okay. And you
So
need,
read that
aside from that, you need to check on this case every week, ma'am, to make sure that this matter is not going forward with other hearings because you will not get another set aside, okay?
Okay, so where do I
Okay,
call? Just call down to the courts every week?
Yes,
And that's the the state court.
correct.
Basically on Pryor.
Correct. To make sure you don't have any other hearings or anything happening. You will not get a second set aside, okay?
Okay.
Okay? The
Okay.
matter is closed. Do not miss any more court dates. You understand?
Yes, ma'am.
All right. Miss Woods, you're free to go at this time.
Thank you.
All right. Oh, wait, Miss Woods, before you go, is it this 1350 Mason Turner?
Yes, ma'am. That's the address that's on
Okay.
file.
All right. And you're going to check.
Apartment E7. Did y'all make sure it's apartment E7?
Okay. We have only the number 7. We don't have an E.
No, it's E7. How do I correct that to put
It says
E7?
E7. It says E7 in the system.
Oh, okay. So we do have it. All right.
Okay.
All right. So you still need to check on it weekly, but otherwise you're free to go. Okay.
Okay. Thank you.
All right. Take care. All right. Can we now go into the competency calendar breakout?
Your Honor.
I'm sorry. Say that again, Ms. Kim.
Oh, I said thank you, Your Honor.
Oh, thank you. Everybody else who doesn't need to be here is again free to go. I don't think we need you, Ms. Greenhouse. Take care.
Thank you. You too.
All right. Bye-bye.
That's it for my cases. May I be excused, Judge?
You may. Take care, Mr. Sirocco.
Thank you. Y'all have a good day.
All right. Bye-bye.
Yeah. Coming up with some stuff. And I think maybe we could do Mr. Sperling's case first.
Okay. You want to do that one on the record since it's a plea?
Yes, ma'am.
Okay. All right. Hold on. Give me one moment. All right, Mr. Sperling, your case is 25 CR 001024G. In this case, you're charged with battery, family violence, and simple battery, family violence with the offense date, of February the 26th of 2025. I'm not sure you heard your rights, so I'm going to explain them. You have a right to remain silent. Anything you say can and will be used against you. You also have a right to an attorney today, and Mr. Bartels is with you to help represent you. As you can see, I'm conducting this hearing by video. It's being live streamed over the internet. It's also being recorded. That means any member of the public can watch the hearing today. Do you understand how I'm conducting the hearing? And do you also understand your rights?
Yes, ma'am.
All right. Ms. Falk?
Yes, Your Honor. On this position, the family violence battery is 12 months, serve 100 days, credit for time served 50 days. No further violent contact with Ronald Camp. FVIP, comply with medications for MH, and count 2 will merge with count 1. We did have a conversation with Mr. Ronald Camp, and he does agree with the plea. We do
Ronald,
also
go ahead.
ask that defense stipulate to venue factual basis on identification for the purposes of the plea. That's all for the state.
We will so stipulate, Your Honor, for the purposes of the plea. We would ask the court to consider, and I guess this will be a non-negotiated plea. We do have the offer from the state that was sent over last week. He served, I guess the sentence would be 114 days to serve because he's been in for 57 days. Credit for time served 57 days. We're in agreement with the requirement to continue taking medication and comply with treatment and no further violent contact with Mr. Camp. I think that in combination with perhaps anger management classes might be more indicated than FVIP. His father is the victim in this case, so it's not an intimate partner violence. And I understand the state is asking for that because of the statute. I think it's 19-13-16A. But the court is allowed to deviate from that if the court states that on the record.
Okay. And the reason for that you believe anger management is more appropriate, Mr. Bartels, is?
Well, my understanding is the FVIP is geared mostly towards intimate partner situations and talks about the cycle of domestic violence. And the alleged victim here is his father. It's not an intimate partner relationship.
Okay. Ms. Falk, will you remind me of the facts of this case, please?
Yes, Your Honor. I apologize. I didn't put the facts on
No,
the record.
I remembered it from last week briefly, but not. I'd like to hear it if I'm going to make any adjustments.
Understood. So this incident happened on February 26th of 2025. The defendant was hiding in the victim was hiding in the bathroom because his son attacked him and had a knife. The officers then made contact, asked him to come out. The victim, Mr. Ronald Camp, came out crying, stated he was fine. They spoke with him. They spoke with the defendant, who stated he would be willing to speak with Grady Crisis only if he's getting paid. They talked to Mr. Camp, the victim, who stated the defendant came home upset, grabbed him, body slammed him onto his head. The officers observed a deep laceration to Mr. Camp's head with blood surrounding it. And based on that, he was taken into custody. Mr. Camp, the victim, stated that the defendant has been to several other institutions, has always been released. And over the past couple of months, the defendant had become more and more physically violent against him.
Okay. And Mr. Bartels, what was your proposal for the number of weeks of anger management?
I think I know I understand the standard is either 4 or 8 or 12 weeks. Is that correct, Ms. Falk?
Yes, Your Honor, I understand the cycles of domestic violence often do apply to intimate partner, but as you also well know, the cycles of domestic violence can apply to family members in a violent situation, such as this one. This one is clearly escalating. Even the victim said the physical aggression had been escalating. He literally had to lock himself into a bathroom and hide from his son. I think we're past 8 weeks of anger management on this.
I would just ask the court for 12 weeks of anger management, Your Honor. Mr. Sperling is on disability, so his income is limited. And I think that it might be setting him up to fail to require the FVIP. I would just ask the court to consider the 12 weeks of anger management in addition to the requirement that he follow all recommended treatment, which I think is probably the root of what happened.
Oh, and I forgot to sound the father's last. I know he's not here, but I'm going to sound anyway. Camp.
Ronald Camp, Your Honor, and the father is 71 years of age.
All right, I'm sounding for Mr. Camp. I do not believe he is present at this time. I want to look up one thing and then I'll make a decision. Give me 1 second. Mr. Bartels, is your concern primarily the cost of FVIP or his ability to comply and complete the class over 6 months?
Well,
Or both?
more of the latter, Your Honor. I mean, the cost is an issue, I think, combined with everything else. I do believe that he could benefit more from the anger management and the mental health treatment. But I am concerned about setting him up for failure as well.
All right. All right, based upon the information before me and having heard arguments from counsel regarding the need for anger management, if defendant Sperling wishes to take the plea, I will order that he needs to complete the 12-week anger management instead of FVIP. Does he wish to move forward and take this plea?
Yes, Your Honor, he does.
All right, Mrs. Sperling, please raise your right. Oh, I'm gonna allow Ms. Falk to state you if you'd like to put your objection onto the record, Ms. Falk.
No,
Or do you
Your
feel you've
Honor.
already done?
Your Honor has laid out the reasons for switching over, which is required per statute. So that's all for the state.
Okay, understood. And you did a great job of putting your objection on earlier. Let's move forward, Mrs. Sperling. Do you please raise your right hand? Do you swear or affirm testimony you give today be truth to the best of your knowledge? All right, you can put your hand down. Thank you. Are you under the influence of any drugs or alcohol that would affect your ability to understand the proceeding today?
No, ma'am.
And you wish to move forward and take a plea at this time?
Yes, ma'am.
And no one has forced you to take a plea?
No.
No one promised you anything in exchange for taking a plea?
No.
And you understand by taking a plea, you're giving up your right to trial by judge or by jury?
Yes.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes.
All right. And you understand that you're going to have to take 12 weeks of anger management as part of this? And do you feel that Mr. Bartels has fully explained all the requirements to you?
Yes, I asked a question. Are they gonna give me directions to where to go?
Mr. Bartels can give you that information, but you do understand what you're supposed to do?
Yeah, I do.
All right. And you further understand that taking a guilty plea may affect other cases if you have them or other aspects of your life?
Yes.
All right. And are you satisfied with Mr. Bartel's representation of you today?
Of course, yes.
All right. As to the charges of battery family violence and simple battery family violence, how do you plead, Mr. Sperling?
Guilty.
All right. I accept your guilty plea. Is there anything additional, Ms. Falk or Mr. Bartels?
Well, yeah, I think that they were charged in the alternative. So my understanding is count 2 would merge with the count 1, the battery.
That is correct.
Oh, that is correct. My apologies. I'm reading the calendar. So he's on. Let's do it again to be clear. Mr. Sperling, as to the charge of battery family violence, how do you plead?
Guilty.
All right. We perfected the record. He's pled guilty. All right. Anything additional?
Nothing further, Your Honor, from defense.
All right. Best of luck to you, Mr. Sperling. Take care. All right.
Thank you, Your Honor.
All right. Now we're ready to go into our breakout.
I'll get it to you. What a photo? You photo? I'll keep my number. You can't go, I'm saying, you give my number too, 44914. Have my number now.
Okay, I'll write it.
44914-3857. 446, I got 2 numbers.
Okay, very well. Thank you, Mr. Smith. I'll do this one. It's been an interesting day.
We're done. Miss Grace